Good morning to everybody. I am Gintarė Bliujien and I am from the Prosecutor General Office from Lithuania, and I would like to present whistleblowers protection model in Lithuania. So let's start. In Lithuania, the law on the protection of whistleblowers was adopted in November 2017 and entered into force on the Thursday of January 2019. So we have our law for about 1 year and 10 months. I would like to briefly describe the specific features of our law and explain how it's implemented. Oh, something wrong with my slides. Okay, thanks. Our legislation system on protection of whistleblowers can be divided into main levels. The main law is the law on protection of whistleblowers, and there are mentioned main provisions in it, the definition of whistleblower, the competent authority and its functions, the procedure of getting whistleblower status, and the set of measures for encouraging and assisting whistleblowers. The other level is resolution of a government of the Republic of Lithuania, and there are approved three main descriptions by it. It's the description of procedure of remuneration of whistleblowers for valuable information, description of the procedure of compensation, and the procedure of introduction of internal whistleblowing channels. And the last one is the description passed by Prosecutor General, and I'll talk about it later. The law on protection of whistleblowers provides that Prosecution Service of Republic of Lithuania is the competent authority which examines itself or forwards to other authorities the reports on breaches and which coordinates the process of protecting whistleblowers. The scheme of examination of reports is provided in the description of submission of reports on breaches and offices to the Prosecution Service of the Republic of Lithuania as approved by the order of the Prosecutor General. So, in particular, all reports are handed over to the Chief Prosecutor of the Internal Investigation Division, and when he directs the received reports to the prosecutor of his division for consideration. Within 5 working days, the prosecutor shall decide either to recognize or not recognize a reporting person as whistleblower, or refuses to examine the report on the basis of the law on the protection of whistleblowers. When a decision is taken to recognize a person as a whistleblower, and if it's established that the prosecution service is authorized to investigate the data mentioned in the report, a division of Prosecutor's General Office or a division of regional level prosecutor's office is assigned to verify the reported information. Also, such division is ordered to ensure protection of whistleblower as provided for in the law on the protection of whistleblowers, and inform about the progress and results of investigations. At the same time, the decision to recognize the person as a whistleblower is forwarded to the competent division of Prosecution Service. It may be that a prosecutor will not recognize a reporting person as a whistleblower, and in such a case, there are 2 options available. So the report simply sent back to the reporting person with explaining the procedure for appealing such a decision, or if there is a reason to believe that another offense, which is not covered by the law on the protection of whistleblowers, has been committed, the investigation shall be started and the report will be handed over the relevant division of prosecution service or other competent authority. According to the Lithuanian law, prosecutor's decision on not to recognize person as a whistleblower can be appealed to the court, whereas a decision on recognizing person as a whistleblower is not subject of appeal. Okay, our law can be said to be strong with many novelties that do not exist in other countries. Protection of whistleblowers is regulated in both the public and private sectors, and there is a possibility to report crimes or other offenses from safe channels. In addition, the law does not require a person to report after he is dismissed or if he is under any other kind of pressure. A person can contact immediately when he wishes to report an offense. There is a very short deadline of 5 working days during which a person is granted the status of a whistleblower, and at the same time acquires the right to multiply protection. Besides, a reporting person does not need to hire a lawyer because we provide consultation to him and help to fill in the report. And we have one new measure from this August. We opened online consultations, and now every person who wishes to whistleblow, they can just call us and get consultation on all questions they want. Many of the provisions that I have mentioned can be found in the Directive on Whistleblowers Protection, adopted by the European Parliament last year. What can the applicant expect? Firstly, we ensure secure channels for submitting reports. According to the Lithuanian legislation, the internal channels must be available in all public authorities and other bodies having more than 50 employees. Secondly, we ensure full confidentiality of the reporting person. According to the directive, it's a duty to protect the identity of the reporting person. However, confidentiality should not be confused with anonymity. The person filling a report must also provide with his details. Such data is required when the decision to recognize or not to recognize a person as a whistleblower is drawn up, and that decision is formalized in a specific form, similar to that of a degree in criminal procedures. Thirdly, it's prohibited to make any negative impact on the person who submitted the information, even if his status of a whistleblower is still pending. Such a person can't be dismissed from work or service or transferred to a lower position or another work, and no harassment, discrimination treats can be used against such person. Also, his career prospects can be limited, his salary can be reduced, and or the working time changed, or it can't be dumped on his competence, or negative information about him can be given to the third parties, or he can't be deprived of the right to work with state or service secrets, or any other adverse effect can be made. These 8 measures are governed in the Lithuanian laws in a narrower scope than in directive. According to the directive, an adverse impact also may include a suspension of training, the failure to extend temporary employment contract to the permanent, and others. So in order to implement the directive, we will have to make amendments in our law to clarify definition of adverse impact. I would like to go further on how applications for prevention of negative impact are dealt with within our institution. Reports on adverse impact are not transmitted via internal or external channel, but are presented directly to the Chief Prosecutor of the Internal Investigations Division of the Prosecutor General's Office. And when the Chief Prosecutor commissions investigation and when he commissions the report to the prosecutor of the division, and during the investigation, the documents submitted by the person are assessed, and some new documents are requested to be presented. If a prosecutor determines there is an impact, the head of the institution concerned is obliged to eliminate the negative consequences. If such obligation is not complete, a fine may be imposed as provided in the Code of Administrative Offences. The fine ranges from 1,000 euro to 2,000 euros, and in case of a repeat offense, it amounts from 2,000 euros to 4,000 euros. And fourthly, there is legal aid. The reporting person can apply for legal aid, and he will be granted with secondary legal assistance granted by the state, regardless of the established threshold of assess and income or to obtain legal aid. Such a measure is also provided for in the directive. One more thing, there is a discharge from liability. The reporting person may be exempted from liability if he has participated in the commission of the breach himself, but he has reported about it in accordance with the procedure laid down by law. However, this is not unconditional exemption in all cases. The provisions are set in the Criminal Code and the Code of Administrative Offences. And lastly, remuneration and compensation. A remuneration may be paid to the whistleblower for useful information, or compensation for the adverse effects incurred may be paid. This effective measure is not included in the directive, but we believe it's an effective measure encouraging people to report about breaches of the law. As I said, the government of the Republic of Lithuania passed the decree on approving the procedure for paying remuneration for the whistleblowers for valuable information, and procedure for compensating the whistleblowers for any adverse impact or possible consequences due to the presented report. On the basis of this described procedure, Prosecutor's General Office has set up two commissions dealing with the issues of remuneration and compensation to the whistleblower. They decide on whether or not to reimburse or compensate the whistleblower, and if so, how much money should be paid. Both commissions assesses the applications of whistleblowers regarding the payment on the basis of the provisions set out in the government's decree. Thus, the commissions are bound by clear criteria, and only persons who fulfill the provisions of decree are eligible to the benefits. The commission submit a reasoned opinion to the Prosecutor General, and when Prosecutor General takes the decision whether or not to pay money. The maximum amount of remuneration is not set in laws, but the amount of compensation may not exceed 1,950 euros. Six requests for reimbursement for valuable information have been received until now, and one of them was upheld, and whistleblower was paid 15,000 euros. Also, there were 2 requests for compensation, and one applicant got compensation for 1,950 euros. So how does the law work? In 2019, there were 75 decisions regarding the status of whistleblower made. 36 persons were recognized as whistleblowers and 39 persons were not. We can say that numbers this year will be higher in about 30%. For example, we had 75 decisions made at the beginning of October, and we think that the numbers will increase highly. And I would like to talk about the results of the investigations. As I said, there were 75 decisions made in total in 2019, and some decisions on not recognizing a person as a whistleblower were not submitted for further assessment because the reported information has already been examined before adoption of the law, or there were other investigations going on. Other decisions on recognizing a person as a whistleblower were not further assessed because pre-trial investigations were already started when an application for the status of a whistleblower was submitted. The information contained in the reports was investigated by divisions of prosecution service or other competent authorities, for example, ministers. Here were 7 pre-trial investigations started last year, and we can say that this year the number will increase because we had started already 12 pre-trial investigations at the beginning of September. On 19 occasions, it was refused to start pre-trial investigations, and there were 10 internal audits and investigations carried out which revealed no breaches, and 7 internal investigations carried out which revealed certain breaches. The most common kinds of violations of law include the unofficial accounting in private companies, abuse of official powers, usage of service costs in violation of regulations, corruption in public procurement procedures, forgery of documents, crimes against environment, violations in monitoring of construction works, violations of labor laws. I have reviewed the legal regulations in our country, which is important in order to ensure a proper protection of a whistleblower. However, having a good law does not mean that this law will function. Therefore, now we put all the efforts to raise awareness of the law on protection of whistleblowers in our country, and incentives and support measures that are guaranteed by the law. And we do that by making public presentations in central authorities operating in regions. We really wish that this law actually works and ensure that people know they would be protected if they report about the wrongdoings. Thank you.